I'm Bridget Stomberg.
And I'm Lisa D. Simone.
And this is Taxes for the Masses.
Today's episode is on Trump's lawsuit against the IRS and the very unusual deal that ended it.
In January 2026, President Trump and his sons sued the IRS for $10 billion over a leak of his tax returns. By May, the case was dismissed, and the Justice Department had signed what it called a settlement that included a multi-billion-dollar fund and permanent audit protection for the entire Trump family. By July of 2026, a federal judge had called the whole thing an improper exercise in self-dealing and referred multiple lawyers to their state bars. In today's episode, we're going to try to make sense of all of this.
Hello, B.
Hello, Lisa. I want to start this episode by asking you a very personal question.
Oh, okay. Bring it on.
Have you ever sued yourself?
I have not. Also, what? Like, how could I sue myself? On what legal basis could I sue myself? And why would I want to?
All good questions.
Okay.
All good questions. You have actually surfaced the correct legal question.
Oh, okay. That's good. I know nothing about the law other than the IRC, so great.
Well, you found some nuggets in there.
Okay.
And we are going to come back to many of those ideas that you just raised, many of those questions. But first.
Yes. Hold on.
Yes.
How was your summer?
It was a lot. It went by.
A lot.
There were ups, there were downs,
Okay.
there were ins, there were outs.
Highlight?
Highlight of the summer was 10-day, 8-day family vacation with my sister-in-law, brother-in-law, mother-in-law, and niece. We did 4 days at the parks, 4 days on a cruise, and my daughter, I think you know this, won $5,000 playing bingo.
That's right. Yes, on the Disney cruise.
Highlight of the summer.
Very nice.
Yes.
That's a good highlight.
And you?
Toss up between watching some World Cup games in Europe.
Okay. Yep.
Surrounded. Yeah. World Cup generally.
Yes, but in Europe.
And even in Austin, it was cool. Like there's a really big Mexico crowd in Austin, as you could imagine. So that was fun. But yeah, then I just got done with a 3-week camper van road trip with my spouse, and we went up the western side of the Rockies, and it was lovely and beautiful and cool and delightful.
And you don't have to teach this year.
I don't.
So I am not speaking to you after we record this, silent treatment.
No, I'm just going to get you drunk, by which I mean I'm going to make you take 2 sips of champagne. All right, so back to the topic at hand.
Yes.
First, we're going to talk about the recent lawsuit between the President of the United States and the IRS, a federal agency.
Yes.
Which I see where you're going here. Sort of like suing yourself.
See, sometimes my ridiculous questions do make sense.
Sometimes. All right. So the plan for today is to give the listeners some backstory, particularly who Charles Littlejohn is and why he matters for this saga.
Okay.
Second, we're going to walk through the lawsuit, how it was handled, how it ended. Third, we're going to dig into the deal, the 2 things the Justice Department called a settlement, and whether that has any legal force whatsoever.
Okay.
Fourth, we're going to walk through the tax law that sits underneath all of this, because there are a couple things that are interesting, for those of us who like to dig into the details and get into the technicalities. Like there's some interesting nuances and a little bit of irony.
You can say nerdy details.
There are nerdy details.
Thank you. Okay.
Yes.
So that's a lot. That's 4 things.
It is a lot.
We usually have 3. That's 4.
I know.
That's like all we had at dinner. This is like a plate that's full, like the food we just had at dinner.
I mean, the plate had 4 enchiladas.
It did. There you go.
Yeah.
4 enchiladas, 4 agenda items. So let's get going.
Yes.
Who is Charles Littlejohn? And who's it? Yeah. Who is that?
Yeah. I don't know what we're doing.
Oh my goodness.
Give me a year. Give me a reference. Give me a medium here. Is TV? Is it a movie?
It's a rapper.
You are asking the wrong person. Everything I know about rap, I learned from you.
All right, we'll get back to this. Go ahead.
Okay, who is Charles Littlejohn? He's an IRS contractor. He worked for Booz Allen Hamilton, which is a consulting firm that provides services primarily to the U.S. federal government. And he was on assignment at the IRS.
And what exactly did he do while on assignment at the IRS? Or I guess, what did he do to make him relevant to the story?
He stole confidential tax return data.
Yeah, that's a no-no.
It's a big no-no.
Don't do that.
Yes. And then he leaked Trump's personal tax returns to the New York Times.
Don't do that either.
And he also leaked tax return data on thousands of wealthy Americans to ProPublica. And we have episodes on both of those things.
We do.
Yes.
So he sprung 2 leaks.
He sprung 2 leaks, 2 separate leaks by the same person in the same time period.
So tell me, Lisa, what happened to Little John? And it is, I just looked it up. I'm thinking of Yeah by Usher featuring Little John and Ludacris. Yeah.
Okay. They don't say yeah. They say yeah. What? Yeah. Yeah.
I stand corrected.
I know the Usher song. Yeah.
Continue.
Little John pleaded guilty and is currently serving time in federal prison. So from a criminal standpoint, that part of the case is resolved. He did a crime. He's paying for his crime.
He did a crime and now he's doing his time. Yeah.
Yeah. In January 2026, Trump and his sons filed a civil lawsuit against the IRS, claiming $10 billion in damages.
Okay, so this is the point, and we want to say this really plainly.
Yes.
Trump, the president of the United States,
yes,
is suing the Internal Revenue Service, which
yes,
is a federal agency, an agency of the United States. More specifically, it's
yes,
part of the executive branch.
Of which
he's quote unquote in charge.
He is the executive. Yes.
Quote unquote.
Yes.
Okay.
That is correct. He is the plaintiff as well as the person who controls the defendant.
Yeah.
Yeah.
Okay, great. So how did the Justice Department respond to this lawsuit? Because the Department of Justice is responsible for defending federal agencies like the IRS.
Yeah. They basically did nothing.
Okay.
They did not raise any of the standard defenses. They didn't raise the statute of limitations.
Okay.
They didn't raise sovereign immunity agreements. They basically just let the lawsuit proceed as though it were legitimate while also negotiating on the side.
Okay. I'm not a lawyer, but none of that sounded great.
It didn't sound good.
It didn't sound like what vigorous defense or whatever that you're supposed to be guaranteed.
Definitely not vigorous.
No. Okay. Then on May 18th, 2026, President Trump voluntarily dismissed the lawsuit with prejudice. Case closed.
Yeah, the court closed it. And the court noted that there was no settlement of record. Nothing had been filed with the court to say this is the agreement to settle the case.
Okay.
But then the very next day, acting Attorney General Todd Blanche, who was at this point Trump's acting Attorney General and also his former personal defense lawyer, signed an order announcing what the Justice Department called a settlement, which again was not on file with any court.
Okay, so there were 2 things in this so-called settlement. Thing 1 was a fund of approximately $1.8 billion called the Anti-Weaponization Fund. We all heard about this around the time it was signed.
Yep.
This was described as compensation for Trump allies who claimed they were victims of government weaponization.
And when you say Trump allies, the reporting noted that this potentially included people who stormed the Capitol on January 6th. And as you might imagine, that set off a little bit of a firestorm. Little, yes. Like immediately.
Yes.
Bipartisan.
Yes.
Senators calling it unconstitutional.
Yeah, it wasn't popular.
No.
A federal judge in a separate case temporarily enjoined the fund. The DOJ said it would comply with the injunction. Thanks for that.
Right.
Blanche later said publicly that the department was not going to proceed with the fund.
Yes. He said that in words.
He did.
Out loud. But he refused to put that in writing.
Of course he did.
And Trump later suggested he wasn't sure whether the fund had actually been dropped.
So we have an oral commitment to not spend $1.8 billion, subject to revision.
That's one way of putting it, yes.
Okay, so that's thing one.
Okay.
Tell us about thing two.
Thing two is the one that didn't cause a political firestorm.
That's nice. That's nice.
Blanche signed a separate order giving Trump, his family, affiliated individuals, trusts, and entities, and I'm going to quote, wide-ranging and unprecedented immunity from tax inquiries.
Okay, as a rule follower,
Yes.
I'm not loving the words that you use, like wide-ranging and unprecedented.
Unprecedented bothers me a lot
It
here.
doesn't feel great. We're talking about immunity.
Yes.
So can you please explain in simple terms for our listeners and for me
Yes.
what exactly that order does?
It basically directs the IRS to stop any ongoing audits of the Trumps.
Okay.
It tells the IRS not to conduct any new investigations of tax returns that they had already filed.
Okay.
It covers tax returns filed before the effective date permanently.
Okay. I would call that unprecedented.
Yes.
All right. So he just filed what he filed and we can't question it.
Stay tuned.
Okay. So why, you might ask, would Trump and his family and affiliated individuals and trusts and entities want this type of protection, you might ask? Money.
Yes, a lot of money. The New York Times previously reported that an adverse ruling in just one IRS examination of Trump could have cost him more than $100 million.
Now, interestingly enough, the Republicans didn't push back on this part of the deal, this thing too, quite the way they did about the fund.
No, not in the same way, and I don't understand it.
Money, 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 money. That was the theme song to The Apprentice, by the way.
Was it?
It was.
I did not know that.
Yep. Okay, so we are not lawyers, in case anyone was confused about that. But there are a few legal questions here that even you and I are smart enough to detect.
You maybe, yeah.
So let's start with the one I think most people are going to ask first. Can the Attorney General of the United States just do this? Can he really just order the IRS to stop auditing the president or anybody for that matter?
So this is where it gets really interesting.
Okay.
And by interesting, I mean, for people interested in law and how our government works.
Okay.
So Congress gave a lot of thought to this.
Really?
Yeah, way back when.
Okay.
And then they left a big giant hole in it.
It's always a mixed bag with that group.
Yes.
Yay for identifying a problem and boo for then just walking away and not fixing it.
Yeah. Okay. So here it comes down to Internal Revenue Code Section 7217, which I had never heard of in my life.
You know things are getting spicy when you're in the 6s and the 7s.
Yeah. Right?
Yes.
So true.
You're
deep. Yes. You are deep
It's a
in the
deep
weeds.
cut.
That code section says, passed by Congress, says that president and certain executive branch officials are prohibited from requesting that the IRS start or stop an audit of a particular taxpayer.
Okay, I want to like what you said.
Right.
But when I listen to it really carefully, I don't love it because you said the president and certain officials
Yes.
are banned from requesting it.
Yes. But certain officials can request such a prohibition, and that includes the Attorney General.
Okay, so maybe I'm thinking about this too simply, but it seems like the code section could have just said no one can request the IRS
Yes.
stop or start an audit of any taxpayer.
Yes.
Even better, maybe it could have said that no one could request the IRS could stop an audit of any elected official.
Yes, there's lots of room for improvement here. And the legislative history on this is not a great story.
Shocker.
The best reading is that the carve out for the Attorney General was meant to preserve coordination between the Department of Justice and the IRS on criminal referrals. So sometimes the Department of Justice apparently needs to tell the IRS to pause on a civil audit while they are furthering a criminal investigation. Okay, so they basically don't want the civil audit to impede on a criminal prosecution.
Sure.
Okay, that makes sense.
Yeah, but that's not what happened here.
No, it is not.
All right, so there is a legal argument that the Attorney General technically can request that the IRS stop or not start auditing certain taxpayers.
Yes.
But Blanche's objective here seems much further reaching than that.
Yes. He purported to forgive tax liabilities outright. Like, not just stopping an audit, right?
Right.
Like, stopping an audit and also saying, like, you cannot assess this amount that you might have already deemed should have been assessed.
Okay. Walk me through that a little bit more.
Yeah. So there are specific statutory mechanisms for extinguishing a tax liability closing agreements, compromises. These are the ways that you formally resolve a tax debt with the IRS. They require specific procedures. You can't just issue an executive order and say, okay, we're done here.
Okay.
So even if that carve out for the Attorney General covers stopping existing audits or starting new ones, it doesn't cover wiping out what the audits might have found. The Attorney General cannot just forgive a tax liability by waving his or her hands.
Okay, so we've gotten to the nerdy portion now.
Yes.
Okay.
Yeah.
So that makes sense. That tracks. And then I think that also introduces a practical problem.
Mm-hmm.
Even if you wanted to do the formal closing agreement process,
Mm-hmm.
Treasury regulations recognize the IRS's authority to enter closing agreements covering the total tax liability for prior periods. But the standard use case assumes that there is an active examination.
Right.
You're closing something that's open.
Right.
The question is whether you can do a closing agreement for a taxpayer who isn't currently being audited. And the answer is, well, A, it's unclear, but also that's not what's happening here either.
Yeah. So as of right now, the audit protection exists as an executive order, but the formal tax law mechanism to make it binding has not been executed.
And that means, and I think this is
Yes.
actually relevant,
Yes.
is that a future administration could actually rescind it.
Yes.
Because over the summer, a judge ruled that the lawsuit itself was collusive and lacked a real controversy. The audit protection directive is functioning as internal executive policy. It's not a binding judicial settlement, which means it can be undone.
Oh, it gets better. Because here's my favorite part.
Okay.
If the settlement terms were effective, and this is hypothetical, and this is an analysis from a pretty cool tax AI product that I've been using, BlueJay.
Okay.
If the settlement is treated as effective and enforceable, so Trump gets what he wants.
Yes.
Okay. Then the audit immunity that Trump received, immunity from audits on returns where a single adverse ruling could have cost him more than $100 million, that immunity that he receives has economic value. Mm-hmm. And what's your favorite code section?
I mean, I know it's my favorite, but
It's not your favorite. What is your most cited code section?
61.
And what does section 61 say?
Gross income, all income from whatever source derived.
And so if this has economic value and he's been granted it as part of a settlement, quote unquote, with a court, the deal that was supposed to protect Trump from IRS scrutiny may have caused a taxable event for President Trump.
That's deep.
We are so in the weeds here.
We are.
But isn't that fun?
It's kind of crazy, but I can see the argument.
It's like debt forgiveness.
Absolutely. His deal with the IRS to give him immunity from IRS audits might actually create taxable income that he would then have to report to the IRS and pay taxes on.
Yes. Now, I should say this analysis assumes the settlement was enforceable, which we don't know is the case, especially given a recent judge's ruling throwing that into serious doubt. But theoretically, and you know, you and I sort of get off on these theoretical tax arguments.
This one's pretty cool.
It's kind of funny to think that the president sued himself, negotiated an agreement to give him something of significant economic value that he's now going to get taxed on.
Absolutely. The irony is not lost on me at all. Okay, so let's talk about the judge, who's kind of key to this whole thing.
Yes.
Her name is Kathleen Williams, Obama appointee.
Oh.
Federal District Court in Miami.
Miami.
She issued a 56-page order on July 13th, 2026, ruling that the lawsuit was an improper exercise in self-dealing. Mm-hmm. She barred Trump from ever calling the audit protections a settlement in any official proceeding. She noted that the lawsuit lacked the fundamental requirement of any valid lawsuit, which is an actual controversy between opposing parties. Like, it doesn't have any of those things.
No, but the opposing parties piece is pretty important.
It's all great.
As she put it, quote, the lead plaintiff and the government are one, a fully realized unitary interest.
Oh, look at her using tax language.
Unitary.
I love it. Which takes us all the way back to the top of the episode and my inane question of, have you ever sued yourself?
Yes. The judge wrote that whether executive branch actors can privately agree to give themselves and their former clients blanket immunities and billions of dollars in tax monies for legally undefined grievances was never an issue advanced to this court. The question is whether the parties could do so by claiming to be adverse and engaging the legitimacy of a court proceeding. The answer is a resounding no.
I think she was pretty clear with her thoughts there. That's not hard to understand. And she didn't just stop at the ruling, which was pretty scathing in and of itself.
Yes.
She referred Trump's primary lawyer in the case to the Florida bar, presumably for some disciplinary action. She also forwarded her ruling to New York for consideration of Todd Blanche. And she referred the DOJ official who signed the paperwork that created that $1.8 billion fund to the D.C. bar. She kept going. She banned a fourth lawyer from appearing in the Southern District of Florida for a year. And she flagged potential monetary sanctions. Any third parties who filed amicus briefs could potentially seek reimbursement of their costs from Trump.
That is a smackdown.
I like it.
Yeah, I do too. Now, the Department of Justice responded by calling her partisan. They said there was a live dispute because the plaintiffs sought relief that the government had not provided. And it's also worth noting that Blanche had testified to the Senate in May that the settlement was never submitted to a court because the case was dismissed and there was no mechanism for reviewing it. But Judge Williams opined on that testimony that the answer is at best misleading and at worst disingenuous.
Ouch.
The court was available to review any pleading by any party at any time during this lawsuit.
Blanche said this while pending Senate confirmation as Attorney General, while already the subject of multiple ethics complaints.
Oh, nice.
And 35 former federal judges had filed to reopen the case.
I mean, I kind of wish I were an attorney or a judge right now because this seems like the most exciting thing that has happened in their world in a really long time.
I mean, it's got to be because if you and I are getting this excited about the minutia, they have to be going crazy.
Right.
Agreed. Okay, time for the good, the bad, and the ugly.
Let's do it.
I'll start with the good because I think I need it after that. It was pretty entertaining, though. But I think the good is clearly that Judge Williams was not taking this lightly.
No.
A sitting federal judge read this record and said, no, this is not how a lawsuit works. This is not how a settlement works. You cannot use a federal court to strike a backroom deal.
Yeah.
So her resistance to the shenanigans was real.
Our institutions are strong for now, hopefully. Some evidence to that in this case. I think it's very good that the anti-weaponization fund got frozen.
Yeah. Okay, how about some bad?
Yeah, the bad. Okay, so it took until Blanche's confirmation hearings getting held up for him to finally put in writing in recent days that the anti-weaponization fund is frozen and to even consider starting to narrow the audit protection orders.
It's incentive alignment, baby.
Yeah.
Right?
I mean,
you don't do something until you really have an incentive to do it. It's gross.
Thank goodness for the two senators who stood up for this and said they wouldn't vote him in until they got in writing that this stuff wasn't going to happen.
Yes, thank you for that good. And now I will follow up with the bad of that, which is you explained to me this morning that the only reason they're doing it is because they're lame duck senators, right? And so
they can piss off Trump, they already have.
Right.
He didn't side with them. They lost their elections.
Yes.
And now, they're holding all the crayons and not letting anybody color until they get their way.
So they have a backbone, but it's maybe just made of a softer material. Yes. I don't know. Something like that.
Yeah.
I think the ugly is this section 7217.
Oh, okay.
So Congress wrote a statute that says the president cannot tell the IRS to stop auditing someone, and they put in an exception for the attorney general.
Yeah.
And the reason there's an exception for the attorney general is totally defensible as a very narrow technical matter. Like there are certain very limited instances where this is good policy, but it's now a clear vulnerability in the tax code.
Yes.
Any future president who wants audit protection for themselves or their allies or anybody else knows that they need to route it through the attorney general.
Yeah.
So Congress has basically handed any future administration a playbook for how to do this.
But this is fixable, right? Congress could tighten this carve out. If it's so clear what those narrow situations are, they could just make it clear that those are the only situations in which the attorney general can do this. Require that any stop to audits go through the formal statutory process under the code sections that exist.
What's so crazy to me is that I haven't heard anything from either side of the aisle about how this happened and the fact that this AG carve-out exists in this code section. It has been radio silence.
It has been quiet. Yeah. So I am not holding my breath that Congress is going to fix this anytime soon.
Not unless you want to pass out.
Well, that's all we have time for today.
Be sure to join us for more tax nerdery on future episodes of Taxes for the Masses.